Hello, everybody. Good afternoon. It is Monday, October 28th. Thank you for joining the Awake Illinois live stream. We are broadcasting across X, Twitter, YouTube, Facebook, and our Instagram. And this is going to be a fun conversation. I'm going to be welcoming on Dean McGee here, Senior Counsel with Liberty Justice Center. I know a lot of our members and subscribers have been very excited to hear some more of the details on this case. So I'm going to be welcoming him on here in just a bit. I want to give everybody an opportunity to share right now wherever you're watching the live stream. So you can share it on your personal social media, share it with your friends, text it to people. This is just a great way for more people in the state of Illinois and really anywhere in the country or in the world who happens to be watching this live stream to share it with your network. So I'm actually going to do that myself right now. I'm going to share it to my Twitter since we are live. And I just want to thank all of you guys for joining us. And we're going to bring on Dean McGee here in just a second. I want to show real quickly, a lot of us at Awake Illinois for the last few years have been fierce champions for parental rights, fierce champions for education policy, integrity in education policy. And so we've worked with so many grassroots organizations around the state and around the country to do right by our children. And so it's really interesting that through this advocacy work, we at Awake Illinois have actually been targeted by the Chicago Teacher Union. They have, more or less slandered us in their resolutions that they've published. This one right here, you can see the snapshot of, is from September 27th of 2023, and they mention Awake Illinois twice, and they say that we are seeking to silence authentic curriculum. What else do they say? They say that we are part of radical extremism. And so, unfortunately, this has just become a highly political time right now for parents and for anybody who's looking to advance ethics in education. So a lot of our members and subscribers are very interested to learn more about this case that has been filed against Chicago Teacher Union. So I'm going to welcome right now with Liberty Justice Center Senior Counsel, Dean McGee. Welcome, Dean.
Thanks, Shannon.
Great to have you here. So thank you for taking the time to talk to us about the great work that's being done at Liberty Justice Center. You can see we've got some bullet points here about the firm, which was founded in 2011. Why don't you brag a little bit about the work that you guys are doing there?
I'll brag, but I can only take credit for the last year because that's okay. When I started there. But
sure.
The organization is probably best known for a win in the Supreme Court, referred to as Janus v. AFSCME. And Mark Janus was a member of a public sector union in Illinois, in Chicago, and he didn't like how his dues were being spent. He thought that the union was spending his money in a political way that he disagreed with. And so he sued to leave the union. And at that time, public sector union workers had no right to leave their union to maintain their government jobs. So you kind of have to step back and think about what that meant. In order to hold a government job up until 2018, you were required to take money out of your paycheck and give it to a union, even if that union represented political views that you disagreed with. And we were able to change that, my organization, through the Liberty Justice Center. Again, I get no credit for that. My colleagues and our current president, Jacob Hubert, took the lead on that case in representing Mark. But it was a really watershed moment for the First Amendment. And, I've heard people talk about that case as anti-union. I just don't agree. I think it's just pro-worker, right? It empowers workers to make their own decisions about how they want their money to be spent. And I think that's a big win under the First Amendment for everyone.
A huge win. And so anytime you hear, a lot of times commentators on the media will reference the Janus case. So it's good for people to have the backstory on that and the fact that Liberty Justice Center was a part of that case. And that was a huge win for the First Amendment. And so you are a pro bono law firm, meaning that your plaintiffs do not have to put money out of their own pocket. So talk to us a little bit about, how that, how are you able to do that? How are you able to defend all of these cases across the country pro bono?
It's through the generosity of donors, and whether that's larger donors or smaller donors, people who give what they can when they can. It's the only way we're able to do the work that we do. And we're a nonpartisan, nonprofit. As you mentioned, every single client we represent is pro bono. And, I spent a career up until I joined Liberty Justice Center, mostly working in larger corporate settings where money was the driving factor behind almost everything we did. And it's so refreshing to be able to represent people without having to worry about their ability to pay.
Absolutely. And so if you're watching this, if you are, a proponent of constitutional rights and seeing plaintiffs get pro bono litigation anywhere in the country, support Liberty Justice Center. This website is here, and we'll keep showing it throughout the live stream because Awake Illinois firmly supports the work that you're doing for Americans. So libertyjusticecenter.org/support is the website. So let's talk a little bit about you, Dean. You're no slouch. You're no dummy. Graduated top of your class. You've been in New York pursuing quite a bit of litigation there. So you come out of the Southern District of New York. For anybody who's not familiar with that, that's pretty big time. And I know that not just because I watched the show Billions. For anybody that's a Billions fan, did you ever watch that show, Dean?
I had to. When I was clerking, it came out while I was there. So
did you like it?
Yeah, it was fun. It was a fun show.
Could you relate to it at all?
Yeah, I mean, the court that I clerked in had a lot of some of the topics in that show were taken right out of the court that I work from. So
interesting.
In that sense, I could relate to it, and I'd talk about it with my coworkers. We'd watch the episode.
I thought it was a smart show. I really liked it. I found it very entertaining. Great cast, and Paul Giamatti plays an attorney in the Southern District of New York. But for anybody who's not familiar with the geography there, that's Manhattan. So there are going to be a lot of big cases in that federal district, and so that's where you had a large part of your career. So yeah, brag a little bit about yourself. I mean, you're no slouch attorney. I have to say, I think the Chicago Teacher Union with this filing that we're going to get into here, they have to be nervous. You're no rookie.
No, I'm no rookie, and I don't like bragging about myself, but I am fortunate to have started my career with one of the biggest law firms in the country, in Manhattan, doing big cases, securities litigation cases for large companies. I spent a year and a half clerking, which essentially means working for a judge in the Southern District of New York, where I got to kind of work on the inside of the judicial system, making sure that we had just outcomes, in the cases that came through that district for a year and a half. So I have been very fortunate. And then I became partner at a firm in upstate New York in a city called Poughkeepsie before I joined Liberty Justice Center. So I've had a good breadth of experience and very happy with where I've landed here at LJC.
Great. Well, thanks for joining LJC. And so we're going to talk about this latest case that you filed here with Liberty Justice Center against the Chicago Teacher Union, representing some plaintiffs. For anybody here in Illinois, the Chicago Tribune published Dean's op-ed last week, October 24th. And I'm just going to read your quote here, Dean, or would you like to read it yourself?
Go ahead.
Okay. So Dean said in this op-ed, the Chicago Teachers Union, representing more than 25,000 educators, touts itself as, quote, the most democratic institution devoted to the city's schools, end quote. But for more than 4 years, the Chicago Teacher Union has failed to publish mandatory audited financial reports, an obligation intended to maintain transparency and trust between Chicago Teacher Union leadership and its members. This raises serious concerns about how union dues paid by educators from taxpayer-funded salaries are being spent. So this was the graphic that was posted when Liberty Justice Center showed the October 8th filing. I think this is fantastic. Whoever came up with this graphic, I want to be friends with this person. Stacey Davis Gates' picture in the background is blurred. You have an adorable dog effectively shredding some audits. So 4 years of missing audits. Let's delve into this. Where do you want to start?
I'll start with the basics, which, the CTU represents more than 25,000 educators in Chicago. It's one of the largest, most politically powerful unions in the country. And they have a constitution and bylaws, which is essentially a contract, a binding contract between union leadership and the members. The members satisfy their obligations under the contract by paying their dues. And our clients have been members for, combined for decades, have always paid their dues. But in response, union leadership has certain obligations to the members. And among those obligations are the requirement that they produce an audit. An audit has to be published to members every single year. And the last time that was done was in September of 2020, and that audit only covered the first half of 2019. So since the first half of 2019, the Chicago Teachers Union has just ignored its obligation to publish financial audits to its members. And, at first, maybe during COVID, they would use that as an excuse. Then you have a year out from COVID. I mean, we're now in 2024, and our clients have no idea how their dues are being spent, at least not from the perspective of financials audited by an outside party.
Wow. Okay, so I want people to see the attempt that was made by the plaintiff in your lawsuit here. There's a document that they reached out to the representative asking for these audits, and there are 3 different emails here. May 1st of 2024, May 3rd of 2024, May 8th of 2024, respectfully asking to see these audits. So you have documentation that they tried.
Yeah, and this is just our client. If you look online, I've been following this closely, obviously, since we filed the case. And you'll see other teachers have posted online in the CTU Facebook group. They'll say, by the way, I've asked for these audits too, and no one's ever responded to me. And so this came from our client. I've had other CTU members reach out to me directly. Others post online that they've also emailed for the audits and never received them. And again, they shouldn't even have to ask. There's 2 obligations that the union has as it relates to financial audits for their members. One is they do have to keep the audits on file for members to be able to view when they request them. But you bypass that altogether because there's this separate requirement. They actually just get published every year to the members. So my client has asked, other C2 members have asked, and it doesn't seem to matter. They are openly flouting their obligations.
Wow. What a shame. And I found this this letter that was sent to you, Dean, from the Chicago Teacher Union representatives, their legal representatives, their attorneys. And I kind of chuckled because he says here that they can inspect the audit simply by requesting to do so, and they can contact this individual, Matt. This was October 9th, just this month that they said that to you, but look at that. I mean, it already happened. So I just got a chuckle out of that. They make it seem like this is all you need to do. Okay, well then do it. They did it. Fulfill the audits. Why aren't they getting a response?
Yeah, I chuckled at that because I knew that Phil had asked and had never seen the audits. And then I chuckled even harder when they threatened us with sanctions for filing the lawsuit. And, it's the pattern of bullying and deflection is so clear here. My clients are being incredibly reasonable. In fact, at the direction of my clients, we could have just filed suit. Instead, we sent them a letter a week in advance and said, we're going to file this lawsuit if you don't publish the audits. So please publish them, because ultimately our clients don't want their dues being spent defending this litigation. Right. They just want to see the audits. There was no need to ever file this suit if the audits had been produced in response to our letter. Instead, we just get more threats.
So in your response, you mentioned here, Dean, I think this is actually really unfortunate. And I think it's actually nothing short of heartbreaking for these educators, for these Chicago public school staffers, that you talk about the retaliation from Chicago Teacher Union against our clients was swift. And that, if I can just read this, that evening during a delegate meeting where one of our clients was introduced as a candidate for the pension board, Chicago Teacher Union's president, Stacey Davis Gates, attacked our clients by name, associating them with, quote, Project 2025, end quote, and baselessly labeling them as, quote, extreme right wing, end quote. Most concerningly, it is our understanding from a whistleblower that on Friday, one of our clients' in-school union reps received an apoplectic, did I say that right?
Apoplectic.
apoplectic call from someone at CTU insisting that they try to stop our client from pursuing this lawsuit. If true, this represents a drastic escalation of Chicago teacher unions' intimidation tactics. This to me is a real shame, Dean.
It's a shame. It may be illegal too, even under their own constitution and bylaws. I want to take a step back just to give you a little more context here.
Sure.
We sent our letter saying that we represent members of the union and we're demanding the audits. Please produce them so we don't have to sue. And we got an email back a week later from the attorneys saying, essentially, please identify who your clients are so we can confirm they're actually union members. And I assumed that was being sent in good faith, that he just wanted to make sure we actually did represent union members. Mm-hmm. But that same evening, the president of CTU was hosting, my understanding it was a Meet the Candidates call for union members running for the pension board, which is a board within the CTU leadership. And one of our clients is actually a candidate, our lead plaintiff, Phil Weiss. So he told me at that meeting, which was available to all delegates, where he was being introduced as a candidate, the president of the CTU read his name and the names of his 3 co-plaintiffs. And that's when she said, this is the extreme right wing within our organization. This has something to do with Project 2025. That was her introduction to a candidate. I mean, she's running a forum that's supposed to be a neutral candidates forum for members to learn about, candidates for this pension board. And instead she slandered and attacked our clients. I don't know my clients' politics. I don't care about my clients' politics, but calling them extreme right wing is so preposterous on its face.
Right. Well, since when is transparency partisan? Right. That's just a standard of ethics for a union, is it not?
Right. It's so blatantly nonpartisan. And, I've seen online, there are members of union leadership who are trying to attack my organization or our clients. And it's been refreshing to see the responses, which have essentially been, okay, even if they were right-wing Project 2025, whatever boogeyman you want to throw at them or slander them with, where are the audits? This case goes away. If they really think our clients are damaging the union through this lawsuit, they could make this lawsuit go away by producing the audits or by telling us, hey, we never did audits properly with an outside financial auditor. We'll do them. We need X amount of time to do them. And I'd negotiate that time frame with them, something reasonable to get those done and produced to our clients. That's all it would take to make this lawsuit go away. So the longer this lawsuit goes on, the more suspicious CTU members have to be about what's going on with their union.
It's a shame because for years now, we've heard from educators in Chicago public schools, certainly, but all around the state where they do feel threatened by the politics of their union, and they do feel that they have to self-censor when it comes to just the basics of the most ethical of standards that they're worried about perhaps being violated. And I do feel badly for educators who just want to focus on educating children. They have found that a lot of the union politics have taken away joy from their profession. And have actually made public schools into just highly political and divided, atmospheres for teachers and students and families. So I'm sorry to see that it has come to this point, but I'm glad that you're taking it on, and I hope that it disrupts some of the lacking transparency here and rights these wrongs. Where is this right now? So this was filed October 8th. Do you have any update, or is it still pending? What can you share about any updates right now?
I don't really have any specific updates as to the case. The defendants need to be served, and then they'll have time to answer our complaint. I have made the offer that I just described to you to resolve this case with either the production of the audits or a negotiated time frame to have those audits conducted and produced. The other really encouraging thing, to the point you were just making, is that if their goal was to try to intimidate our clients into dropping this lawsuit or to scare other union members away from asking for the audits themselves, they've failed, because we've actually had a number of CTU members reach out to us asking to join our lawsuit, more than we'll even be able to add to the case if we wanted to. So their intimidation tactics are failing spectacularly.
I'm glad to hear it. Well, it's time to disrupt this. And I feel badly for these teachers that are caught in the middle. I'm glad you're doing this work. And, I know from people who are in some of these Facebook groups, they're closed Facebook groups on social media, but snapshots are showing that these political bureaucrats of the union they appear to be panicking. So it'll be very interesting to see where this lawsuit goes and what resolutions come about for it. But I look forward to seeing the audits. And I guess that Stacey Davis Gates, although she has blocked Awake Illinois on Twitter, we welcome you, Stacey, to do right by your union members and to resolve this swiftly. And it seems like it should be a pretty easy thing to fulfill. So we'll see where this goes. But I'm glad that you're doing it. What other statements do you have to make about this case before we move on to some of the other great work you've done at Liberty Justice Center?
I don't have any other statements about this case, but I've really appreciated the outpouring of support from people throughout Chicago. I'm a New Yorker. It's not my home city, but I've really gotten the sense that people have had these concerns for a long time, and we're happy to give voice to our clients and to others by filing this suit.
That's great. Well, we're hopeful, and we'll be keeping everybody updated on this and keep up the good work with it. And obviously, we applaud your clients on this case. It took courage, and to be an outlier, especially in this time, it requires just an incredible amount of grit and courage. So we salute them for taking this step, and we hope that this gets resolved swiftly. So let's move on to some of these other cases. You have all at Liberty Justice Center done such great work. And parental rights has been a huge battle across the country. It's often in the news where this is just a battleground topic right now, whether it's Illinois or anywhere else. And so I would like for you to be able to talk about California. And Illinois mirrors California in many ways. Our governors are very similar, and a lot of the war on parental rights is as strong here as it is in California. Why don't you talk to us about how you're challenging AB 1955 and what this legislation entails and why you're tackling it?
Will do, and my colleague Emily Ray deserves the credit for these cases. And this started with our representation of the Chino Valley School District in California, which passed a policy that said, sort of among many other things that it wanted parents notified about, it passed a policy that said, if a child has requested to transition their gender in school, that the school would just let parents know that happened. Wouldn't even require parental consent or anything like that, which is something that a lot of conservative organizations have pushed for. And this school didn't do that. They just wanted to notify parents of a pretty drastic change in the student's interaction with the school. And Attorney General Bonta of California sued Chino Valley for that policy, saying that it was illegal under the California state constitution, and sought an injunction to prohibit that policy from going into effect. While that case was being litigated, California passed this bill, AB 1955, that essentially made those parental notification policies illegal throughout California. And so Liberty Justice Center, again led by Emily Ray, filed a lawsuit against Gavin Newsom and Attorney General Bonta in the state of California to stop AB 1955 from being implemented.
And this would go into effect January 1st, 2025, correct?
That's my understanding.
Okay, so this is something that has parents very concerned across the country, particularly as they delve into the agenda of stripping parents away from what is actually happening with their child in preschool to 12th grade classrooms across the country. So any clinician worth their salt knows that children do better when they have parent involvement. So this agenda to strip parents away from these pretty serious situations with their children, this to me shouldn't even have to be litigated. But here we are in a time where parental rights are under attack. So this was filed in July. Are there any updates, or it looks like it might still be pending right now?
It's still pending. The state has moved to dismiss our case, and of course, we're opposing that, and that's standard legal practice. So, this will ultimately be decided by a federal judge out in California, and if need be, it'll be appealed up to the Ninth Circuit, and then we'll take it to the Supreme Court if we need to.
Okay, so we'll be keeping an eye on that. Again, a huge issue, parental rights across the country, and we support all parents that want to be, involved with their children. They want to know exactly what's happening in their children's classrooms, any confusion that is happening with their children. Of course, parents are paramount. So thank you for doing that work on this particular case. And actually, the Chino Valley district, the school board president there, I had the pleasure of meeting her recently at a Parents Defending Education event, and that's her on the left there. I was so struck by her courage and her bravery, because she has been up against a significant amount of what I would call cancel culture and censorship and intimidation. And this letter that you put forth to Meta platform, social media, on her behalf, basically what was happening with her was through her parental rights advocacy and her voice in championing parents and constituents of her district. When people went to Meta-owned platforms like Instagram and Facebook, they received a warning message that said, quote, "We think your search might be associated with child sexual abuse," and warned that searching for such material can lead to imprisonment and other severe punishments. So Meta did take corrective action on this, but the harm to her reputation and just the intimidation and the attempt to perhaps censor her, this is extreme, is it not?
It's extreme. It's baffling. It's infuriating. And I was very sorry that she went through that. And I was glad we were able to get that resolved for her.
Yeah, absolutely. But this is happening across the country. You see even our Facebook page gets shadow banned, and anybody who's championing parents and liberty, justice, ethics, truth, all of this, they get targeted. And so I'm really glad that you stood up for Sonia, who's in the thick of it right now with the parental rights battle in these cases. So good work there, and props to Sonia Shaw. I am so impressed by her, and she is just such a role model for a fierce mom and an elected citizen keeping her oath to the constituency. So follow her on social media and keep following this case, because this will set a strong precedent for school districts across the country, won't it? This one.
Yeah, it will. And one more thing I want to say about this case, our expert that we retained in this case is a transgender woman, Dr. Erica Anderson, who had in the past was involved with WPATH, which is an organization, transgender medicine professional organization, and Dr. Anderson takes the same position that Sonia takes, which is that parents have to be notified when kids are going through something like this, through or expressing those feelings in a school. It's really important for parents to get involved, whatever the outcome is, because ultimately, kids need parental involvement for these substantial life changes and decisions, things like that.
Right. In the parental rights, as they are protected under the Constitution, the 14th Amendment, those rights are not granted to any parent by Governor Newsom or Governor Pritzker or any politician. Those are fundamental, right? And it's just a shame that we're in a time where we're literally having to litigate this purely to protect the fundamental rights of parents. So again, great work here with this pending suit. Great work defending Sonia. I'm just a huge fan of hers. And this is a really interesting case here with the free speech for the doctors. Again, California. But what happens in California doesn't stay in California. So everybody pays close attention to these lawsuits for case precedent. But in Illinois, particularly when we launched in 2021, health freedom, medical freedom, First Amendment rights, this was a big battle here. We have the Healthcare Right of Conscience Act, which was a state law, and that was being challenged at the time. And there were actually a lot of physicians who were worried that this was going to affect their free speech and their ability to, to speak clearly to whether it was COVID or anything else, the abortion, any number of medical topics. And so people were actually flooding our organization asking for help. How do we get legal help? How do we get assistance? So why don't you talk to us about what happened with this particular court case? It was filed in October of 2022, where it was repealing the physician censorship law.
California passed a bill that effectively made it illegal for doctors to disagree with the CDC. And this was, right after the experience we all went through with COVID, where we saw how quickly scientific consensus and medical consensus was shifting. But California legislators ignored that entirely and essentially said to doctors in California, you have to conform to the official government health narratives or you'll lose your license. And Liberty Justice Center sued on behalf of doctors in California. And we actually lost at the trial court level, the district court level, and appealed it to the Ninth Circuit. And oral argument went so poorly for the government at the Ninth Circuit. 3 judges were just not buying what the state of California was selling on this bill. And it was such a catastrophe for the state. It was so obvious that they were going to lose that they actually rushed through a bill to repeal the law before the Ninth Circuit could issue its decision. So they mooted the case because they realized that when they reached that level, there was no way that law was going to survive the scrutiny under the First Amendment.
Excellent. Well, again, it's just a shame that it has come to this point. But I love how in this update, it talked about how, I think this was it, where it just like quietly went away. They just conceded the inevitable and quietly repealed the law. I just love that. They got spanked on this. So Newsom, Pritzker, very similar. Illinois was waging war on the due process rights of students. We actually, our family was on a lawsuit to get the restraining order against Pritzker, the State Board of Education, the Department of Public Health, and more than 146 school districts initially for the forced masking and quarantining of students, which was a violation of the Communicable Disease Code in state law. So because of the restraining order that was brought down here in the state of Illinois, that forced and compelled Pritzker and, all of his bootlickers to basically not be able to coerce any longer. And they said, oh, now it's local control. Oh, how convenient. But we needed to sue, right, in order for that to happen. So litigation is so important to maintain sanity, to maintain order, and to preserve justice and constitutional rights of the citizenry. So I'm glad that was repealed. Great work there. But it took a year, right? It took a year for that that victory to come about?
It took a year, and they defended it up until the moment that they faced that panel of judges before the Ninth Circuit. And then I think they were so scared of getting an adverse decision that was going to set precedent, they rushed through the bill to repeal the law that they'd passed a year prior.
Wow. So this is why it's so important. There aren't enough courageous attorneys or law firms out there, in my opinion. I think for a while there was like a saturation of attorneys coming out of law school. And now I think there's maybe, I don't know, is there a deficit in people getting their law degree these days?
I think it has. I think the numbers have shifted the other direction, as you're saying. But
yeah. But nonetheless, there weren't enough that had courage. And so Liberty Justice Center, for anybody watching, if you are a supporter of constitutional rights, due process, free speech, please consider a donation to them, libertyjusticecenter.org/support. They're doing amazing work to preserve your rights as citizens. And so I don't believe there are enough people with courage to step up and challenge a lot of the assault on liberty that's happening. So whether you believe your rights have been violated or you're a supporter of the work being done here, please support Liberty Justice Center, because this is just, you guys are doing such great work. So thank you.
Thank you.
These are some of the notable cases. So after this live stream has wrapped at the blog, we'll have all of the slides available, and people can click all the different cases that we've covered. They can get direct links to these cases, follow for updates. And these are some of the other cases. We touched on a couple of them. Any of these other ones you want to real quickly recap for anybody that we missed here?
I see one that stands out to me just because it's my case. Christian McGee,
Okay.
CM v. Davidson County Board of Education. So Christian is a client of mine, a 16-year-old boy in North Carolina who was suspended for 3 days out of school for asking a question in his English class that used the phrase illegal aliens. And
Oh, that's right. I remember this. Okay.
And he was suspended, and the assistant principal actually told him that it was the equivalent of saying the N-word, that he had to be punished as if he had said the N-word for using the phrase illegal aliens, which is so drastic and so outrageous. If it's one thing if the district had wanted, had said to him, by the way, there are some people who do find this term outdated or offensive, may turn into a learning opportunity. His parents wouldn't have had a problem with that. But to harshly suspend this kid for asking a question, for using a phrase that same month was used by the United States Supreme Court, that to this day is enshrined in U.S. law, it's preposterous. And so, we have to remind the Davidson County School Board in North Carolina that students have First Amendment rights too. There's a 1969 Supreme Court case, Tinker v. Des Moines, where the school tried to punish Mary Beth Tinker, an 8th grade Vietnam War protester who wanted to wear a black armband to protest the war. And she very bravely took her case all the way to the Supreme Court and won. And that was the first time that courts really clarified that students have First Amendment rights in school. So we're dealing with that in North Carolina, and we feel good about that case too.
Good. And that was filed May 7th. So good luck to that student and to you as you proceed with that. I like this here, saying illegal aliens is not racist. I find that in a lot of the discourse, people are self-censoring on that. My message to you would be stop censoring yourself. And if somebody tries to violate your First Amendment right to free speech, I guess they could call you guys, right?
That's right. And we mean that. We're very proud of the work we do. And if people do feel their rights are being violated, we encourage them to go to our website and reach out to us.
That's great. And so these are some of the notable cases that all of you can follow up with these links afterwards at the blog. Please support libertyjusticecenter.org/support. Every little bit helps. And as I said, I don't think there are enough courageous firms taking this on. And the fact that you guys are doing it at no cost to your clients is huge. So bravo to the work that you are all doing. And I wish you all the best of luck as you continue litigating and defending people across the country.
Thank you, Shannon.
Thank you so much. So Dean McGee, we're going to follow up with you. Just keep us posted on updates. Keep sharing it. We'll share it on Twitter as you guys post any updates on this case. This graphic is phenomenal. I just love it with the dog. And I just think it's adorable, but also pretty profound. So thank you, Dean. I'm going to just have 2 more slides here to share with all of you. And I hope you share this live stream with everyone. I know in Illinois, people are really interested in the nuances to this case. It's actually pretty simple. I bet you could litigate this in your sleep, Dean, based on your bio, but we're glad you're doing it. The teachers deserve transparency with their union. And so families and citizens across the state are going to be keeping up with this. So tomorrow we have another live stream. We're going to have Josh Cedar coming on. He's actually an Illinois native and former Bachelorette contestant who spent months pretending to be transgender, and it went viral. And it was just this crazy social experiment where he exposed the left for being delusional, as he would say, and is now a face for women's rights and sanity. So we're going to have a fun chat with him tomorrow at noon, again, same time as we started this live stream today, and it will be recorded afterwards. And something new that we're doing at Awake Illinois is offering a business, a brand, individual, or a cause to sponsor a live stream. So more than 100,000 viewers will learn more about whatever it is that you want to share as a sponsor. And if you want to contact us with interest, let us know. But thank you again, Dean and Liberty Justice Center, for your time today. This is going to be helpful. And I hope that people share it, and we'll be following your cases going forward. Thank you again.
Thanks for having me.
Of course. All right. libertyjusticecenter.org/support. Thank you so much for tuning in. Share this, and have a great afternoon. See you guys on tomorrow's live stream. Thanks, Dean.
Thanks.
I really hope you enjoyed it. We had a ball making it. Thank you very much.